let everyone know that the Public Defender Services Commission has 2 new members. They are Celia Howes and Chris Thomas. Both of them are going to add a great perspective and experience to the commission. Celia Howes is a longtime criminal defense attorney who practices largely in federal court, but also has done a lot of state court work in the past. And Chris Thomas has a great deal of experience with mental health issues in Oregon and has done a lot of work in the mental health service provider community. And their full bios are on our website, and I would invite everyone to check them out. But we're extremely pleased that they've agreed to join the commission, and they're going to add a great deal of experience and perspective to our work. The other couple other things I just want to make everyone aware of and reiterate is, as everyone knows, our accounts payable division, we are going to, starting January 3rd, be requiring online submission for all invoices, and that will begin this coming Monday. There is a very helpful video that walks everyone through the process, and I invite everyone who hasn't checked out that video to please check it out. It walks you through step by step the new online submission form. Our hope is that this will streamline things, make things easier for providers, quicker, and will also expedite our turnaround on paying invoices. With this, for all invoice submissions, an email address will be required for all invoice submissions beginning January 3rd. One other thing we want to do is note that our non-routine expense division is being renamed. It is now Case Support Services. I think, as all of the providers recognize, investigation experts, those kinds of things, they are not non-routine expenses. They are routine expenses for criminal defense cases. And so we need to rename that and have everybody, both internally and externally, recognize that these are not non-routine expenses. And regarding the training video, it is in the agenda, and there is a link to it so you can all look at it. Couple of other very important things I want to acknowledge. Interim Director Ed Jones and Vice Chair of the PDSC, Elizabeth Welch, are ending and leaving us at the end of this month. And we are very appreciative of their services to the commission and to the agency. We could not have gotten through the past year or even survived without their services, and we really appreciate what they have lent to the community in terms of going above and beyond what anyone could have expected from them. In terms of case backlogs and attorney capacity, as everyone knows, we have a shortage in Oregon of criminal defense attorney capacity. I want to thank a number of attorneys and contractors and providers who have stepped up to the plate over the course of the past several months, and particularly acutely over the past month, in terms of assisting us. Eagle Cap defenders, Morrison Sullivan, particularly Caleb Berthelsen and Richard Balsley, John Lambord, Josephine County Defense Attorney defense lawyers, the Juvenile Advocacy of Clackamas County, Lynn Defenders, Lori Schmidt, Los Abogados, Southwest Oregon Public Defense Service Providers, Umpqua Valley Public Defenders, Stunts Fonda, Vidrio Parks and Jarvis, Russ Barnett, Martin Thompson, Angela Lee Madlin, Westbrook Johnson, Laura Shantz, Ed Neustetter, Ben Anderson, Henley LaShure, Liz Langford, Karen Mochrin, and Linda Gouge. All of these folks have stepped up to assist us with the case backlog. We still have a case backlog. It is much lower than it was when I first started at the beginning of the month, and it is much lower because of all of the folks that I listed who have stepped up. One other addition to the office that I want to make sure I acknowledge is Adelita Hernandez has joined our contract analyst team. She is a new member and joins our very experienced team, and she is getting up to speed and will soon be able to fully take over a contract analyst position. So I want everyone to know that she will be joining us more fully in the coming weeks and months. I think I've covered everything I wanted to cover in terms of introductions and ingoings and outgoings. Autumn.
Thanks, Steve. I'm going to talk about legislative update as the government relations manager here. And I want to start because we're going to talk about provider compensation first, if you guys are following the agenda. And I really want to thank all the folks that have spoken up, particularly in public comment at the PDSC meetings. I know that the PDSC meetings are long and we put the comment at the end. So I want to make sure that I thank the people that have waded through and provided helpful comment. Also, I know there's been many other people that have reached out to the agency through other means, email, calls, all those things, regardless of whether they're super positive comments. We very much appreciate hearing from all of you, and it's helpful to know what's going on out there. So that kind of leads us into a discussion that came up at the last PDSC meeting, which is about provider compensation. And I know that that is high on everyone's mind. So we want to let you know that in the May e-board meeting, which is the emergency board of the legislature, we are going to be asking for a portion of the $100 million holdback. And with that, we anticipate with a partial release, at least being able to provide a 3% increase into the next contracting cycle that will start in July. That's sort of already budgeted for in our budget, but we have to get part of the $100 million in order to implement that already pre-planned out budget. But in addition, we're going to need to ask for more money than that. It came up from the last PDSC meeting. They have been listening to the providers and they're sympathetic and supportive of pursuing more. So we plan to ask for more money than just that 3% at the May e-board. And, you know, we don't necessarily know whether we'll get it or not. We'll do our very best. And we haven't worked out the exact details about what the ask will be because we want to make sure that it's well packaged before we're going to the legislature to make that ask. But even if we're not successful with something beyond a 3%, we will be planning to lay good groundwork going forward into the next cycle because the e-board meets about every 3 months. So it's not as if we have to wait for a million years to ask again or to continue to stay on the radar of the legislature. The other thing on the agenda for legislative update is the House Bill 2003. Just a little bit of background on that. It's kind of the final vestiges of House Bill 3145, if you all recall. several years ago with House Bill 3145. That was really the response to the Sixth Amendment study coming out. And there was a big push for a major reform in the way that OPDS contracts. And sort of the last few pieces from that original legislation are what ended up in House Bill 2003. It's not exact, but a lot of the same ideas came from that. So it passed the legislature in June of 2021. It went into effect on passage because it had emergency clause. It calls for policies, plans, systems that support massive improvements in compensation, resources, and caseloads, and sticks a lot of those policies to national and regional best practices. So I mentioned that because it sets us on a path in a direction that the agency is really excited about. But in order to get down that path, we need to have both the ABA study to adopt back to the national and regional best practices. So we're not relying on the NAC standards from the 70s, and we're actually looking at current data and current data that is related to Oregon. We anticipate that in the middle of January. They are on the agenda of the next commission meeting to be presenting the actual results of the ABA study. So they've got a pretty clear deadline at that point. We're not in control of whether they meet their deadline or not, though. So we're very hopeful that that is what happens, and we kind of need that to move forward on 2003. Also, we need the CAP division, which is kind of the next agenda item on the list, because Aaron Sevier is going to be talking about CAP. So I won't go into a lot of detail there, but there's a strong connection between 2003 and House Bill 5030, which was our budget bill, which is the things we have to meet in order to get the 100 million holdback. So it's good for everyone to know that House Bill 2003 also did not include any funding. So there was no money associated with the passage of the bill. So all it is a set of standards, policies, plans, systems to head in the right direction. But we're going to have to come back to the legislature to ask for money after we have a solid plan for how the implementation will happen. So we're in the planning stages for now. But there is a report that is required to be given to the legislature, and that will be published and submitted to the legislature by the end of January. We'll be sharing that also out with the providers as a part of that report. So those are the items I have. I think we were going to kick it next to Aaron Sevier to do a 5030 update, because I know that Steve wanted to have a little extra time to talk about the discovery costs, because that's the hot issue right now.
Hi, everyone. I'm going to quickly share my screen. I've got a PowerPoint to share. So as you know, I'm Erin Sevier, and I'm a Deputy General Counsel at OPDS. I'm planning on doing sort of two updates, a real quick update on the stakeholder engagement, and then also, as Autumn foreshadowed, another brief update on the build out of the compliance, audit, and performance function. This one's a little bit more important because we're at a turning point in what the work looks like there. And so I want to talk about what to expect next. So on the stakeholder engagement, just to show you, our surveys had gone out a couple of weeks ago. We've had really excellent responses. And I just want to appreciate everyone on this call who completed the provider survey. I particularly want to call out those who shared with their non-attorney staff. This is the first time we've heard from those people in any kind of surveys to our office. And a triple thanks for any of those who distributed it to the justice system stakeholders in their jurisdictions or shared the client survey with clients. The provider and justice system stakeholder surveys close tomorrow on December 31st. So if you have not yet taken those, please do so now. The surveys that we received by December 31st will be included in the insight report that the commission is using for its strategic planning. We can keep the surveys open past that point. And so if you still have feedback to give and you can't make that December 31st deadline, you can still go ahead and complete the survey, but it will not be included in that insight report. We are talking about extending the client survey. A number of you have reached out to me for paper copies to distribute to clients. I can distribute paper copies, but we've had some logistical issues with that, which is one reason why we're thinking about extending the survey deadline for that. And there we go. On the compliance, audit, and performance new division, should be repetitive of what you've heard from me before here and also during the PDSC meetings. This is really briefly just about what CAP is and why the agency is developing this function within this function. We've also talked in past meetings about what our broad goals are for CAP. As Autumn was saying, this is something that came out of our budget bill. We are required to do this in order to obtain the 100 million held back from the general fund. But the goals that we have for it are more transparency, support for quality and effective representation, better program management, and increased accountability and oversight. We think this will enable us to provide more reliable financial forecasts when there are changes in the public defense environment, which will help us do a better job of funding, better justify specific budget requests and demonstrate return for the legislature on that, and better evaluate and support quality and effective public defense practices. This is sort of a broad view of where we're at in the CAP development. This just describes the core work that the CAP division will be responsible for. It's important to recognize that there are some pieces of this work that are being pulled from other parts of the agency and centralized in the CAP division. For example, things like policy development and monitoring of attorney qualifications. Another thing to emphasize here is that one of the big changes that CAP brings from what we were able to do before is really only the only part of the agency that provided direct supports to attorneys was our PCRP program. And it's foundational to CAP that we will be able to provide greater support for attorneys practicing in criminal defense or dependency in non-PCRP jurisdictions. This is just a staff chart that describes our preliminary assessment of who will do this work. These are the positions that were funded in the budget bill. A number of these positions are actually being reorganized from other parts of the agency, so they already exist and they're just shifting over into CAP. Hard time with my slides today, I'm sorry. Just a minute. As I was talking about before, a number of pieces of the work that were previously being done by the General Counsel, for example, are moving over to CAP. And why that's important for you all is if you were working with one of the Deputy General Counsels in a particular role, some of their duties may be shifting. Who's doing that work and where that work is located may be shifting. That stuff, then that pertains to things like attorney qualifications, resolving complaints, and reviewing and approving like case support services requests. So we are reaching the stage where we're completing what is sort of the internal facing side of developing the compliance audit performance function and shifting over into building out what the external facing part of what CAP will do, what those supports will look like, what the attorney and entity compliance will look like. And we start on that in the new year. So I think as we start moving through these updates, we'll be able to provide kind of more details about what CAP is going to mean for everyone on this call and how we will be able to be a much better partner in supporting your work. So stay tuned. That's all I have.
Thanks, Erin. Okay, perhaps now we're ready to turn to something that a lot of you are on the call for and are interested in. And I wanted to do this last and next to the Q&A. And I have no problem if the questions in the Q&A portion go beyond and even well beyond what was initially scheduled. I want to let you all know I've been monitoring the pond on which there's been a lot of discussion of this issue. I spent most of yesterday responding to a number of comments that I felt were worthy of response and needed responses, and also talking to a number of providers who had questions about this issue. First of all, a number of things. One is, we understand, and I understand, that this is a change in the way things have been done previously in Oregon. We know, and I know and understand, that change can be hard and it can be difficult. However, it is important to not let the fact that change is hard and difficult prevent us from engaging in needed and necessary change. I also want to let everyone know I've thought very hard about this. I've thought through it thoroughly. I've experienced this in lots of other jurisdictions, and based on all of the questions and issues I've seen discussed both in emails to me and on the pond, I feel very comfortable that there are adequate answers to all of the changes. I also think that people are perceiving this as being a larger issue and more complicated and complex than it actually is. You should all know that there is nowhere else in the United States, state or federal, where the costs of discovery are funded through indigent defendants or indigent defense service provisions. There is nowhere else that does it this way. And all of these criminal justice systems all over the country, in all of these states and in the federal system, they function just fine without it being done this way. Cases don't stop, work doesn't cease to function, the system doesn't collapse, everything proceeds along just fine. So I am confident that we can do this in Oregon and things will be just fine and we will be able to proceed just fine. This is not going to cause system collapse or work to cease or work not to be done on behalf of clients. But I understand it is a change. Couple of things in reference to some comments I've seen. There were a number of comments about indicating or expressing that this should have been handled legislatively. This was explored thoroughly. We have been offering and attempting and doing everything humanly possible to meet with the district attorneys and the District Attorneys Association in order to try and work with them collaboratively in order to achieve collaborative solutions together to present to the legislature. We have spent a lot of time talking to the key legislators, and they have expressed that they would like us, OPDS and the District Attorneys Association, to work together collaboratively and present them with solutions or ways to address this issue. For whatever reason, the District Attorneys and the District Attorneys Association has not found the time to meet with us to work on this. I think that we all know that there are likely reasons for that. One of those reasons is maybe that they didn't really believe we would follow through on this, and so they were planning on things just continuing as is, while they continued to basically delay and stall and not meet with us. We currently do have a meeting scheduled with them for January 12th. And we have consistently indicated to them that we are ready, willing, and able to meet with them and eager to meet with them to assist them with issues related to funding the cost of discovery. Again, for whatever reason, they haven't done so despite our outreach over the past several months, and particularly intensively over the past 6 weeks. They now have found themselves able to meet with us starting January 12th, I think in part because they have seen that we are now following through on this. We have spoken to the legislature. Right now, there is not currently a vehicle in the short session for us to advance a legislative fix. If we come up with a legislative fix between now and the legislative session, we and the District Attorneys Association will contact the legislature, and we'll see if there is a way that there is a vehicle that we can address this through. But we will pursue that. Now, in terms of the bottom line details, okay, I know that previously this has been framed in terms of SB 751 and the change in language to the discovery provisions. That all predated me coming here. From my perspective, this change is not simply the result of the change in the discovery statute effectuated by 751. Quite frankly, it wouldn't have made a difference to me. As I made clear in the memo, it was never appropriate under the previous language, under any language, for the costs of discovery to be funded on the backs of indigent defendants or the indigent defense system. That was never appropriate. It wasn't appropriate before 751. It's not appropriate now. I can tell you that the language in the federal system and in most other jurisdictions tracked the language in Oregon's discovery statutes prior to 751. And yet nowhere else did anyone think it was appropriate to try and fund discovery costs on the backs of indigent defendants or the indigent public defense providers. So really, quite frankly, for me, 751, all it did was raise the consciousness regarding this issue, but it didn't make a difference, and doesn't make a difference. So when district attorneys or others reference 751, as far as I'm concerned, it's a rabbit hole. You're going down the wrong track. It's not relevant to me, and it doesn't matter in terms of how the costs of discovery are funded. We have made, in addition, we have made clear to the district attorneys. We fully support district attorneys being provided with the necessary funds so that they can comply with their discovery obligations. We have no quarrel with that. We will support their requests that the state properly fund them in order to comply with their discovery obligations. But that cannot and should not be done through the Office of Public Defense Services. It's not appropriate. We are not staffed or structured to monitor those costs. And that's just not a function that public defense provides. If district attorneys' offices need funding to fund the costs of providing discovery, be it statutorily mandated or constitutionally mandated, they need to seek that funding directly from the legislature. And they should do so. Now, couple of things on just how this works. My understanding is that in the large majority of jurisdictions in Oregon, local district attorneys provide discovery to attorneys in indigent defense cases, just like they do in cases that are retained privately. They then, in the large majority of jurisdictions, they then send the billing or invoices for the cost of that discovery directly to OPDS, directly to us. That will continue, I anticipate. So the local providers in those jurisdictions where OPDS is billed directly, nothing changes. The local providers request discovery, you get discovery. If you don't get discovery, you pursue discovery through motions to compel and whatever other mechanisms you've previously been using. The local district attorney's offices will send the bills to OPDS as they have in the past, and we will address them. Nothing changes. In those jurisdictions that have not been billing OPDS directly and where they have instead been sending bills or invoices to the local service providers, the local service providers should just continue as they were before. Request discovery. If you receive a bill or invoice for discovery costs from your local district attorney or prosecuting authority, accept it with a smile, then forward it to OPDS for payment. Do not pay it directly because we will not reimburse you. Forward it to OPDS and clearly mark it as being for discovery costs. We will then address it just as we would address billing coming from prosecutors, district attorneys, that comes directly to us. Okay, so again, nothing will change. You request discovery on behalf of your client, you pursue it through vigorously through motions to compel or whatever other means. If the local district attorney sends you an invoice or a bill, accept it. You don't need to get into a fight with them over it. Not your battle. Just forward it on to OPDS and clearly mark it as being for discovery costs. One thing I should mention is that this change in policy starts 1/1/2022. So for discovery that was provided that is provided prior to 1/1/2022, it will be paid. So if there are past bills that you are paid, that service providers have paid, or that OPDS is or in the future receives invoices for discovery that occurred or was provided prior to 1/1/2022, we will pay for it. If local providers or attorneys paid for it, we will reimburse it. Okay, this is only for discovery provided after 1/1/2022. So you do not have to worry about anything that has occurred in the past. This is future only. So either the district attorney will either send OPDS the bill directly and we will address it, or they will send it directly to the attorneys or service providers. You will accept it, and then you will forward it to us to handle, clearly marking it as being for discovery costs. Now, at some point in the future, it may be, some sooner, some later, that when local district attorneys find that we are not paying their invoices or billing, that they will refuse to provide discovery without prepayment, because they will say to the provider, look, OPDS isn't paying this, so I'm not going to provide it to you unless you pay for it in advance. This is no different than any other legal issue that you all confront in your daily work. You request discovery under the statute on behalf of your client. If the prosecutor refuses to comply with their obligations for whatever reason, doesn't matter what the reason is. If the reason is money, okay, fine. If the reason is because they don't want to provide it, or they don't want to provide it in a timely fashion, you treat it the same way as any other legal issue. The first thing you should do is immediately notify OPDS that you have a case where the district attorney is refusing to provide discovery without prepayment of the costs. We will then provide you with support, both litigation and otherwise, in order to vindicate your client's rights. But again, it's no different than a Fourth Amendment issue, a Fifth Amendment issue, a hearsay issue, a Daubert issue, any other evidentiary issue. You pursue it vigorously in communications with the assistant district attorney. If they still won't provide it and you've laid a good foundation that you've clearly made the request and have pursued it vigorously on your own, you then file a motion to compel and you litigate it in court. We will help support you in that. We will have motion templates and the like to provide you. You'll bring it to the judge's attention. The primary thing to understand is, and in litigating this issue, is there is no provision in Oregon law that authorizes the district attorney to fail to provide discovery in lieu of payments from indigent defendants or their providers. There just isn't one. I have looked through the statutes myself. I've invited the district attorneys, defense providers, the defense community. I've asked someone to point me to any provision in Oregon law that authorizes the district attorneys to pass on these costs to us. So far, no one has pointed to me to any provision. And so what we are doing here is we are attorneys, and in my case, I'm a state employee. As both an attorney and a state employee, we are compelled to follow the law. The law doesn't provide for this. So we're going to start following the law. The fact that the law wasn't followed previously, that's not an excuse to continue to violate the law. I don't think any district attorney would accept the fact that the law regarding any criminal offense wasn't previously enforced as an excuse not to enforce it going forward. That's all that's happening here. We're going to follow the law. I believe they should do so as well. So you'll file a motion to compel. It will get litigated in front of a court. A court will rule. If a court is saying to the defense provider, why aren't you paying for this? The answer is the law doesn't permit it. The law doesn't allow it. And judge, if you or the district attorney can point me to the provision that authorizes the DA to charge indigent criminal defendants for the costs of discovery, please point us to it. What law are you relying on to impose these costs? Okay. I haven't seen one. Again, if somebody wants to point me to such a provision, I am more than happy to look at it. But you should ask the judge and the district attorney to specifically point to what provision in Oregon law authorizes this. Because I think you will find, and they will find, there is no such provision. Now, if the judge denies the motion to compel, it's just like denying a motion to suppress. It's just like denying a motion in limine to exclude evidence. If a prosecutor in a case seeks to introduce inadmissible hearsay, you object. If you have time and it's in advance and you know about it in advance, you file a written objection and a memorandum of law outlining why the hearsay is inadmissible. You then argue it in front of the judge, and the judge rules. If the judge rules against you, I am absolutely confident that all of the criminal defense service providers in the state of Oregon have extensive familiarity with judges denying meritorious motions that they have filed. You file it, you litigate it. If you get ruled against, you object, you note your objection, you preserve the issue for appeal, and the case moves forward to resolution, either through a plea or through trial. If the person is convicted of anything, they have an appellate issue that's been properly preserved. I don't see this as any different than any other legal issue that we all deal with. Judges will deal with it differently in different circumstances, and different judges will deal with it differently, and we will litigate it accordingly. But that's the procedure. So, one, bills will come directly to us, and we will handle it. If bills and invoices go to local service providers for discovery, you accept it with a smile, forward it on to OPDS, clearly marking it as being for discovery, and proceed. If the DA refuses to file to comply with their discovery obligations under the statutes, you treat it just like the DA failing to fulfill their obligations under any other statute, or as you would have previously had they failed to provide discovery for any other reason. You object, you pursue it with them. After you've exhausted that, you file a motion to compel, you litigate it in front of the judge. If you win, you win. If you lose, you note your objection, you preserve the record for appeal, and you proceed. I think that's really all I have to say. I just want to reemphasize, there is no other place in the country that does this, and their criminal justice systems function just fine in most respects. And again, I understand this is a change here in Oregon, but it's a necessary change. It's a change that I believe is required by the law as it is currently set forth in Oregon statutes. And so, as I said, I believe all that we are doing is saying we are going to now follow the law. We will continue our outreach with the district attorneys and the District Attorneys Association to try and work with them at a legislative solution. As I indicated, we are currently scheduled to meet with them January 12th. I can't promise that will happen. We have tried to meet with them in the past, and they have continually pushed it back or canceled. But we are hopeful that now that we are instituting this policy, that they will meet with us on the 12th, and that we will be able to work collaboratively together with them. With all of that said, I now want to open the floor for questions, and I am happy to listen to any questions and answer any and all questions you all may have.
Oh, can you hear me?
Yeah, it's a little low. Can you raise your volume?
I can raise my voice. This is
Great.
Guy Greco from Lincoln County.
Hi, Guy.
Hi. I've just pulled up the statute, and I want to get your comments on the way the statute's worded. It says that the district, and I understand what you're saying about the rest of the world. I mean, we had 10 person jury verdicts here forever and ever, too.
Well, I came from, just so you know, I came from Louisiana, the only other jurisdiction, and I wrote I wrote a substantial portion of the cert petition in Ramos.
Yeah, I know you came from Louisiana. The statute says the district attorney shall disclose the discovery. It does not say, it does not define disclose. It does not say that the district attorney shall make copies or send it to you. And so what I've always had in the past, when I deal with this crap, over 40 years of it, is you'll get a district attorney that says, well, we'll disclose it. Come on over to the office and bring your notepad. But, you know, if you want to use our photocopying machine, you're going to pay 25 cents a copy. Of course, today now it's all electronic, which drives me nuts because they charge us the same rates just to, you know, ship it to you on an email. But what I'm concerned about, and also I'm fairly tuned into our judiciary, that we're going to hear that. Well, if it's not going to get paid for, then you go over there and look at it. And I wondered what you think of that tactic, because I think it will occur.
Okay, first of all, the statutes in most other jurisdictions, including the federal statute, Rule 16, uses the same language, disclose. Nobody interprets disclose as authorizing the prosecution to require an indigent defendant to pay. That's number one. Number two, the Oregon statute currently defines disclose as, quote, providing. So that doesn't hold water anymore. Third, I think this is a key point that a lot of people are missing. The disclosure requirement is not to the lawyer. It is to the client. The client is an indigent defendant. You are simply requesting it and facilitating the disclosure in a representative capacity on behalf of the indigent client. So, if you could imagine for a second that you're at a point at which charges have been filed and the discovery obligations are triggered. If the client has an absolute constitutional right to represent themselves under Ferretta versus California, the client could represent themselves and say, I want all of the discovery I'm entitled to. The district attorney could not require an indigent defendant to pay for their discovery. They would have to provide it. The indigent defendant could then review all of the discovery and look at it and say, wow, this is really serious. I need a lawyer. And if indigent, they would be entitled to a lawyer. So please understand, it is not the lawyer that is getting the discovery. You are merely getting it for your client. Your client is indigent. They can't be made to pay if they can't afford to. So I think the district attorneys are confused and think that because a lawyer is asking for it, that the lawyer has money and therefore the lawyer is obligated to pay. You are only requesting disclosure or discovery in your representative capacity on behalf of your client. Your client is indigent. Your client therefore is entitled to it without payment. In essence, and let me just finish. In essence, their position is that if you are wealthy, you are entitled to have discovery, but if you are poor, you are not. I don't think that will stand up in court.
I get that. Okay, but I'm not familiar with this SB 705 you mentioned, but I did
751.
When I again looked at the statute, and it says disclose means an opportunity to inspect and copy. That's not saying they have to do it.
That's not.
I understand everything you said. I'm just
okay. Okay, you're looking at the old statute.
Yeah.
The old statute says disclose means to provide. Okay. So one, you're looking at the old statute. Two, but second, and I want to emphasize this, the federal statute says the same thing. If your indigent client is in jail, the district attorney saying you can come to my office would not satisfy their obligations. So the problem is the same. So I don't think it changes anything. And again, this has been litigated in the federal system, and it is never held up that they could charge.
I see now that Bob Holman has his hand up, but I just want to let people know, in case you can't see the screen, that it says that just raise your electronic hand, or if you're only on a telephone dial-in, you can pipe up and say your name, but it looks like Bob Holman is waiting with his hand up.
Thank you. Bob Holman, Lane County PD. So I've been doing this for 40 years too, along with Guy. But hey, I agree with you completely on this. I think we've been doing it wrong for years. If we get an adverse ruling, though, I would suggest maybe a mandamus proceeding, because I think an appeal is going to be not going to be an adequate remedy.
I think that depends on the case. As I said, if you get into a situation, if anyone, but I take your point that exploring a mandamus is a good idea, but recognize that what's going to happen is if a prosecutor, if a district attorney refuses to provide discovery without prepayment, that the attorney should immediately contact OPDS. We will then work with the provider to litigate it in the trial court, and then on a case-by-case basis, depending on how the judge rules, the exact way in which the judge rules, right? There may be sometimes where the judge rules without a hearing, right? There may be lots of different circumstances. We will work with the attorney to pursue the appropriate remedy, whether it be a mandamus, whether it be preserving it for appeal, based on the specifics of the case. But we will already be involved with the provider prior to it reaching that point, if the providers are doing it properly as we are requesting that they do. Now, if providers decide to go it alone and go it on their own, obviously there's not much we can do. If we don't know about it, we can't provide support and we can't help, which is why I would urge all attorneys and all providers who are handling indigent defense cases, if you run into that situation, contact us right away.
Thank you.
Thanks, Bob. Anybody else have a question that they want to? The only way we're doing it is by voice, so you have to speak up. I don't see anybody else.
Going once, going twice. All right. Well, you all have my email address, so you're welcome. People are welcome to send me emails. I can't promise I'll be able to respond to every single one of them, but I will do my best to respond to those that I think are on point and will be of interest to the wider community.
And I just want to give an opportunity in case anybody had any questions related to any other part of the provider call too that wasn't related to discovery, just in case you thought this was only for discovery time. All right. Well, Happy New Year.
Everyone have a great new year, and let us know if issues arise.